Mention. Good.
Also, appear for listing 3 matter for Urdu levels. Supplies. Tomorrow.
Daily list for motion. Item 1.
Hello. Yes. I think this matter has got infractions because subsequently speaking orders passed and they have challenged and they have got interim order also.
Okay. Let them come.
Let them come.
Supplementary list. Item 16.
Yes, madam.
Yes, my lord. Here I have got 2 points. One, no judgments, I have got 2 points, my lord. But regarding that notice where yesterday senior counsel have pointed out that why you have not you are cooperate with the, not cooperate, why you have not appeared before the
For your information, there is a judgment of Rajasthan High Court, right?
Rajasthan, Delhi High Court I have.
Delhi High Court,
Yes,
Rajasthan High Court, 67-4.
Yes, yes, my lord. I
Right.
have it.
There, the Rajasthan High Court had said that you have to cooperate and go, and there is alternative remedy,
Yes, my lord.
right? And that judgment has been challenged before the Supreme Court,
Yes, my lord.
right? And interestingly, that is the case of Murliwala pigment,
Yes, my lord.
right? Then a detail order has been passed initially on 21/5/2026. There, it says that the appellant contends that section 67(4) of the CGST Act, sealing of premises can be done only if access is denied.
Yes, my lord.
In the present case, section 64 of the Act has no application. Independently, that is another one. Then, interestingly, the hearing of the case is fixed at 2 p.m. today
Yes, I have.
before
I
the
was-
Supreme Court.
I was supposed to point out the 67(4). It was never denied and all this, my lord, by the petitioner, my lords.
No, it is closed. There is formation of an opinion that you did not respond,
Yes, my lord.
and phone call at so and so number is there. So in that case, everything will be decided today at 2 p.m.
My lord, I have a judgment of Delhi High Court where.
I have seen,
Yes, my lord, that Naveen impacts.
but that Rajasthan High Court judgment is detailed, running into 25 pages. That is more detailed.
Yes, my lord, here in this Delhi.
I
High
have
Court-
read.
Yes, my lord, it is like.
Justice Robinder Bhatt.
Yes, my lord.
I have read.
Second paragraph, it is written that till the petitioner has
It
not
is more detailed.
cooperated as it is not with the produced. My lord, here it is not a matter of.
Madam, you
cooperate.
wait for, we'll issue notice. You wait short notice. Where is Mr. Kyle?
My lord, the
Yes,
house
coming,
has
Because of
till the
Supreme Court-
25th, my lord, till date, they are like homeless, they are
Madam,
suffering, my
don't
lord.
insist for,
No, my lord. My lord,
because
I pray
that
for.
formation of opinion has been recorded in the order, in the summons, oh sorry, prohibition order. Let us wait 2 p.m. what happens. But otherwise, premises can include residence also. That has been more detailed. The Rajasthan High Court has discussed everything. Have you got the Rajasthan High Court judgment?
No, my lord. I have got the Delhi only.
That is, Mr. R.S. Mishra has provided yesterday.
Yes, my lord. I have also bought yesterday, my lord.
That is short, but more detail is the Rajasthan High Court. And that has been challenged. Rajasthan High Court, it has gone against the SSC.
My lord, I pray.
Where is Mr. Kyle?
he is coming, Lordship.
Better, his assistance is required. Wait for some time.
17. Item 17.
Yes, Mr. Majumdar and Talukdar.
Yeah.
So this is a cooperative society, right?
Right.
If I have remembered correctly, then on 9/6/2025, additional register of cooperative societies, 9/6/2025,
Yes.
dissolved, appointed
One man, yes.
one man committee as board failed to hold AGM election in time.
In time.
That is ground. That is the
Exactly.
ground. Then on 17/8/2025, one man committee formed a managing committee as no nomination was
Fine.
received. 14 members were chosen to form the managing committee,
Exactly.
and many of them are from dissolved managing committee.
They, you couldn't hire that
Earlier.
committee, yes.
So there was an inquiry, but whether ARCS has approved that,
Yes, it was approved.
when
Just after election.
election.
Election, that is selection, as there was no
Okay.
election.
In the inquiry report, it is mentioned that
Yes,
it has
yes.
been approved.
Yes,
Then 19/8/2025, a complaint was received.
yes.
Who submitted that complaint?
This is interesting. Some members, they were also part of the earlier society. And they were in that meeting and they had made a complaint to the CEO. This complaint, inquiry was initiated on that complaint. And finally, the inquiry report,
So CEO means that one man management,
yes,
one man.
one man.
So he forwarded the matter maybe to the registrar or whoever,
And
maybe. So an inquiry was initiated.
yes, inquiry report was
So in
prepared.
the meantime, first meeting of the board of the managing committee was held.
Yes,
Minutes were approved.
yes,
Okay. Then a hearing.
that's it.
Hearing took place on the complaint. On the complaint.
Hearing took place on the complaint, but they were there. The member of the board of directors were not heard. They were not invited.
Okay.
to participate in the
Thereafter, on
hearing.
29/12/2025, Deputy Registrar of Cooperative Society submitted an inquiry report.
Report, yes.
Right?
Right.
Then it was placed before the registrar.
Raised.
Then he held the hearing.
Yes.
He held the hearing and passed that impugn order.
Impugn order.
Now, Mr. Talukdar, just few queries.
Well,
Suppose right or wrong, board managing committee was formed under the superintendence of that one man committee. That mandate has been approved. Mandate has been approved on the same day, surprisingly. First meeting was also held. That was also approved by in charge assistant registrar of corporations. Now, thereafter, a complaint. On the basis of a complaint, perhaps inquiry can be initiated, right? Under section 87. 87. Of not less than 1/3 of the director or of not less than 1/10 of the member. Complaint is to be received. Hold an inquiry or cause an inquiry into any specific subject relating to any violation of any of the provisions of this act. That is 44A, perhaps.
44.
40 subsection 4, clause A. Next 2. the registrar shall order an inquiry or reject the application for an inquiry showing the region within 10 days from the date of receipt of the application. Then 3 inquiries shall be completed within a period of 30 days from the date of order of the inquiry. There is a proviso. Then 4, the registrar shall within a period of 30 days communicate the report of the inquiry to the cooperative society. Right.
Right.
Then 5, the cooperative society concerned shall on receipt of the report place it before the next general meeting or in a special general meeting to take such action thereon as the general body may think fit, or which may include removal of all or any directors and election of new directors or any other action of any employee as required. Right.
Right.
Now, can you look at section 125?
About in the opinion of the registrar.
I don't know whether it is applicable or not.
Yes.
I am just
Before the performance of the duties imposed. One 25 specifically, my lord, lays down the, I think, my lord, the grounds on which supersession can be done. So the grounds are if he
because I don't know, in charge assistant register, because he approved the minute. So, by virtue of delegation, that is an order of the registrar himself. But still he can supersede the body
Yes.
after causing an inquiry.
Yes.
If I am not wrong,
Correct.
87, first jurisdictional fact which is to be in existence is either 87. There is a complaint.
Hmm.
It must be from at least
1/3 of the
directors
Directors.
or not less than 1/10 of the
members.
Then he will get the jurisdiction.
Yes. Irrespective of the approval by the ARCS. Yes.
But otherwise, that is an order of himself
Yes.
indirectly.
Hmm.
So he gets the jurisdiction
Under 87.
87 to inquire into any matter.
Hmm.
And by the end of section 125, he can supersede. And that such appointed person shall arrange for holding election of a new board of.
Yes.
So whether this procedure is correct procedure, but I am understanding it.
Yes.
The way I have understood.
Yes, my lord, because your lordship will see, my lord,
Because otherwise they incur the disqualification.
Hmm.
But that has been approved, right or wrong. That meeting, new formation of new committee.
but lordship will see what has happened. My lord, the procedure prescribed is by way of election. That is the scheme. Now that is, my lord, discarded. And my lord, by selection, the board is constituted. Now the procedure is prescribed under the election rules.
Right.
How the election is to proceed.
I have
This is
understood, but
absolutely-
you, Mr. You have approved. That
Correct.
is the problem for the court.
Correct, my lord.
That is the problem for the court. By virtue of notification,
Yes.
you have approved them.
Correct.
This is the difficulty
Yes,
faced by the court.
Yes, yes, I understand, my lord. So under 87, the another door is open.
Door is
Irrespect-
open,
Yes.
but to initiate an inquiry,
Yes.
there must be existence of the jurisdictional fact that there must be a complaint
Yes, yes.
by not less than this much of director
Yes.
or by not less than 1/10 of the shareholders.
His requirement has to be met.
That whether that has been met or not.
Yes, this is.
Because he will derive jurisdiction only and only then,
Yes, yes. Otherwise not.
not.
So Lordship may issue notice, my lord. I'll obtain instruction and I'll.
Right. Otherwise, one can go for appeal.
Yes, yes.
That is before the state government.
Mm.
Otherwise, he will derive jurisdiction to pass this impugn order. But there must be condition precedent. That
But if your lordship holds other way around in respect of that issue which is open before your lordship, my lord, that the register, irrespective of my lord, the order is passed by the delegated my lord officer, can my lord exercise the power of appeal or revision, then perhaps my lord he can do this. My lord, that issue your lordship will decide it, set at rest. That is still open. Other writ petitions, my lord, are pending.
I am not deciding it unless I am sure.
Yes, my lord.
There must be something on a record from the department.
One thing is that lordship, the complaint.
No, here your lordship will issue notice. What I am trying to say, that issue is still.
We'll only keep this second part in abeyance.
Yes,
Second part.
second part.
We will not observe anything on second part of the impugn order.
Regarding disqualification, my lord.
That for necessary action for conducting fresh election.
Oh, that part, yes, yes. That will serve the purpose, my lord. It will, my lord, balance the equities, my lord.
Because court can take notice also,
Yes,
but subject to receipt of response,
my lord.
that as a whole it is illegal.
My lord.
44A.
Yes.
As a whole, it is, so we can go to that extent,
Right.
but let us have
Right.
a response from the other side.
Lordship,
No election,
no election.
Your purpose is, sir.
Yes,
only that much.
that much. The remaining part will be decided at the later stage.
No restoration at this stage.
No election and
No election.
lordship.
Heard. Mr. F.Z. Majumdar, Learned Counsel for the petitioner. These 5 and 6, they are what? 5, 6, 7 and 8.
They are complaining.
What day?
Interestingly,
Where
lordship,
is their complaint? Where is their complaint?
complaint is there in the page number. Page number 16.
And you- which- Declare. Members.
Lordship may take.
Members.
They are also member of the another cooperative society. That document I have also annexed. These complainants holding position of two different.
An
cooperative
advocate can be a member of High Court Bar Association as well as Lawyers Association,
No,
Assam.
that can be done, but there
Whether
is,
any restriction
yes,
in the Cooperative Societies Act
yes,
Why?
42.
42. Let us see. 42. Forty-two.
42 that it is about the disqualification. The
42. 42.
40 within bracket 2.
Okay. 40 within bracket 2. This is regarding attendance or in two.
Now, patronization word is there. They must patronize the patronize the
If
services
such
of the
member has
cooperative
patronized the
societies.
services of the cooperative society during the financial to the extent and in a manner specified and has attended. This is qualification.
This is other way round. He will-
Other way around.
He will be eligible if he has patronized
Ah.
in respect of that cooperative society. This has nothing to do with another cooperative society.
And that at this stage, Lordship, I am not, it will come.
They are said that they are members. They have said they are members.
Members and
Now
they-
question is that how many of them have filed this complaint? For the register to cause inquiry. Mr. That is an important issue.
My lord?
Because
Huh.
how many members
Huh.
have filed a complaint?
My lord.
They are in the capacity of members, they have filed a complaint.
My lord.
To derive jurisdiction under 87,
1/10.
110. Learned Council, Learned Standing Council for the Learned Standing Council Cooperation Department, Government of Assam for the respondent number 1 to 4. Full stop. Para. SL is made in this petition, SL is made to an order dated 1/7/2026, passed by the Registrar of State Government is not a party. Registrar of Cooperative Societies, Assam, within bracket. Respond number 1. Full stop. 1/7/2026 full name. In the order. In the MP order. The respondent number 1 has observed that the previous board of directors, BOD or board of Messrs. Gwalpara Wholesale Consumer Cooperative Society Limited, within bracket the society, failed to hold the annual general meeting, within bracket AGM stroke election within the stipulated time, and there is inclusion of members from that board in the new board of the society, who are ineligible under section 40 within bracket 4 within bracket small a of the Assam Cooperative Societies Act 2007 within bracket 2007 Act, and moreover, the chairman and the vice chairman are ineligible under section 40 within bracket 4 of the 2007 Act. Having observed so, the respondent number 3 has been directed to take necessary action for conducting fresh election to the board in accordance with the existing rules, in accordance with the provisions of the 2007 Act. Full stop. Para. Issue notice returnable on so and so. As Mr. Talukdar, the standing of property department, has appeared and accepted notice on behalf of the respondent number 1 to 4. Issuance of formal notice to the said respondent is dispensed with extra copies 2 working days. Steps upon respondent number 5 to 8 by speed post within 2 working days. Para. From the materials on record and as per the submissions of the Learned Council for the petition, The response number 2. On 9/6/2025 had dissolved the previous board of the society and under section 41(6),
41(4).
41(6),
Which one, my lord?
that resolution of
Yes, yes, 41.
for failure to hold.
Yes, yes, 41(6).
Under section 41(6) of the 2007 Act, for its failure to hold the AGM stroke election in time and appointed one-man committee. Post op. On 17/8/2025, the one-man committee convened the AGM of the society to hold election. Correct?
Okay.
Full stop. As no nomination was received for election to the board, the AGM choose 14 members. 14 members
14 members. That's
for formation of the managing committee of the society. Full stop. Out of those 14 members in the new board, how many?
exact.
A majority of those members, or a number of them.
Because it is in complaint, it is said the number of. They didn't
A
mention it.
number of them were directors in the previous board, which was dissolved on 9/6/2025. Full stop. Para. Apparently, the proceedings of the AGM dated 17/8/2025 was approved by the Assistant Registrar of Cooperative Societies in charge, within bracket, on 17/8/2025 itself. First, para on 19/8/2025, a complaint was received from a number of members of the society alleging that in the new board of the society, a number of directors were included who were directors in the previous board dissolved on 9/6/2025, and therefore they were not qualified to hold to act, to be elected, to be a part of the new board, in view of the disqualification clause in section 40 within bracket 4 within bracket small a of the 2007 Act. Supposed to be transfers that on receipt of the complaint, said complaint, comma, an inquiry was initiated. We don't know who has caused the inquiry.
Yes.
Materials are not there.
Well,
Post of. Para. It is stated that the first meeting of the new board was held on 6/9/2025, and the proceedings of the said meeting, first meeting of the new board, was approved by the ARCS in charge on 6/9/2025 itself. Post of. Para. Proceeding on the complaint, comma, a hearing was scheduled on 27/11/2025. And thereafter, comma, and thereafter on 29/12/2025, comma, the Deputy Registrar of Cooperative Societies, Goalpara, within bracket respond number 4, submitted an inquiry report that is part of the Annexer C. Post. Thereafter, a hearing was conducted by the respondent number 1 in his office on 22/6/2026 in presence of the persons mentioned in the impugn order. First of, the chairman and the secretary of the society were had also attended the hearing. Post. Para, the petitioner has questioned in this repetition. The petitioner has questioned that if the inquiry initiated on the basis of the complaint dated 19/8/2025 under section 87 of the 2007 Act, then the condition precedent for an inquiry to be initiated on the basis of a complaint like the complaint dated 19/8/2025. The complaint must have to be submitted by inter alia by not less than 1/3 of the directors, comma, or of not less than 1/10 of the members of the society. Full stop. Such condition was not met in the case in hand, and therefore any inquiry based on a complaint which has not met the condition precedent is ab initio void. Full stop. It is the contention of the petitioner that the impugn order has been passed based on such an invalid complaint, and therefore the impugn order cannot be acted upon. First of Mr. It is in response, the Land Standing Council Corporation Department has submitted that based on a complaint, the Register of Cooperative Societies can hold an inquiry into any specific subject relating to violation of any provisions of the 2007 Act or bylaws. Post. Oh, it is a contention. It is the further contention that after holding an inquiry, the registrar has to communicate the report of the inquiry to the society concerned, and thereafter the society concerned has to place it before the next general meeting or in a special general meeting to take such action thereon as the general body may think fit, which may include removal of all or any directors and election of new directors or any other action, removal of new directors or election of new directors. The respondent in the case in hand, the racer, respondent 1 did not communicate the inquiry report to the society to place it before next general meeting or in a special general meeting to take an action thereon. After after receipt of an inquiry report, the findings recorded therein need to be acted upon, the register is authorized to take action under section 125 of the 2007 Act. And he can supersede or keep the board under suspension and appoint one or more administrators from the department to manage the affairs of the society for such period not exceeding 6 months, and such appointed person and can direct the appointed person for holding election of a new board of the society. Para, the petitioner has projected that has projected a number of infirmities in the process. One, that the condition precedent to hold an inquiry under section 87 of the 2007 Act was not made in the case in hand. And two, the inquiry report was not communicated to the petitioner society to enable the society to take a decision on its own by convening a general meeting or a special general meeting. Right? These are the things.
Yes.
Having primarily satisfied with the projection made on behalf of the petitioner, it is observed, in the interim, that there shall not be any action for conducting fresh election for the board of directors of the petitioner society till the written will. The respondent authorities in the corporation department shall file their affidavit in opposition, traversing the contention made by the petitioner in this writ petition. Traversing contention pleaded by the petitioner in this writ petition. Really?
Yes.
9th September.
These are whether
0909.
any precedent is there or not.
Regarding my lord,
Any authority, settled authority,
in respect of which my lord?
judgment
The issue, my
in
lord?
this issue.
This issue. No, my lord, I think your lordship
No,
requires.
I have extensively searched since last 2 days. I didn't find anything connected with the section 87. But there is one judgment of Justice Bodua. He discussed the section 40 within bracket 2 regarding disqualification. I have a copy, Lordship, I will supply it.
Item 18.
Sorry, to any mind.
May I please? My lord, before going through the my lord, identical order, I would like to my lord, draw your lordship's attention just for a moment, my lord, page 16. Page 16, my lord.
60.
16, my lord.
16.
16.
16.
Yes. Now, this is the my lord, CETA copy to the subject plot of land. Now, right hand side lordship will find Kramot Ali. They are the grandparents of the petitioners. This. Now, next page lordship will find page 17.
70.
Page 17.
This is what document CETA.
Yes. This is CETA copy, my lord.
So basically it is Dakhal,
Yes.
possession.
Possession. Now, lordship, kindly see for a moment, my lord. Page, my lord, 19.
19. Yes.
Yes, it was, my lord, Kesapatta in favor of the my lord petitioners. Then, my lord, page 20, lordship will find the date of my lord Kesapatta. 8/7, I think, my lord, 8/7/1992.
These are in the name of
The petitioners.
aforesaid Ali.
Yes.
Ab-
Abu Al Hussein, Abu Bakr,
Ataur
Ataur.
Rahman.
Yes.
Page 19, Ataur is mentioned.
Yes, page 19, not mentioned, he is the son of Abu Bakr.
So they are predecessors.
Yes, predecessor. Now, lordship, kindly see, my lord, kindly back to the my lord, page 16. Again, my lord. Their operative part, lordship, will find page 17. My lord, in the below, my lord, right hand side, ceiling number 100, so and so.
Page 17.
17, 17.
Which part?
Right hand side, my lord.
Right hand side.
Yes. Ceiling case, I think, my lord, 100, so and so, Gosur, Chorkar.
It might look like that it could be riot also.
Right.
It could be riot also. Page 17.
17.
Honmotikome Jurdari or something. এৰি দিয়াৰ বাবে 1, 2, 3 নং পটাদাৰৰ স্থলত riot.
Yes. Then, my lord, right hand side, my lord, below,
Uh,
it has been mentioned. my lord.
dealer can look into all these aspects.
Yes.
You have mentioned. You have mentioned.
My lord. Now, lordship, kindly see the impugn order. We have challenge here. Page 31. Page 31, my lord.
Hey, Public Service Act Fund.
Page 31. Under the Bosundara scheme, my lord.
This is settlement of khas and ceiling surplus.
Surplus, sir. Page 31. Rejected, CO, rejected by CO.
Right. Then 32 also.
Page 30.
And
also,
33 also.
And 33 also. These are
And page 31 is for which petitioner?
page 31, my lord, Zakir Hussain. Sorry,
Petition number?
Ataur Rahman.
Petitioner number.
Yes. Ataur Rahman. Ataur is, my lord, petition number 2.
2. Okay. Come to page 32.
32, my lord, Zakir Hussain.
Petition number?
His petition number 4.
4.
4.
And 33?
33, my lord, Israfil Haq, petition number 3.
3.
Yes.
And this petition number 1 means page.
Khurshid Ali.
1 minute. Zakir Hussain. 1, 2. Where is 1?
Yes. One, my lord, rejection order is not available. We have charged.
Rejection order is not available.
Now, after that, my lord,
He is son of, I think, Ataur.
yes,
Ataur Rahman is brother. His
Yes.
brother.
brother,
Their father is Abu Al Hussein Sarkar.
yes,
I think
Khurshid
they
Ali.
have filed one application.
yes.
Single application for both of them.
Might be. Now,
You are not sure.
yes. After
Might
that,
be,
my lord,
might be.
after that, my lord, page 66, lordship, kindly see. Page 66.
নতুন ফের দুনিয়া এখন উড়িয়ে গেছে কোথায় গেছে তাই মনে করছিল হ্যাঁ কি নাই Where is that notification regarding DLR? Or it was in the order?
In
you
the order
placed?
itself, my lord, it has been quoted. my lord. Now, page 66, lordship will find appeal filed by the my lord petitioners, page 66.
Yes.
That appeal is still pending, my lord. It has been recently filed, my lord, on 27/2026.
Against those
Rejection order.
rejection order.
Yes.
এখানে নেই হ্যাঁ হ'ব জানো এইটো মামৰে লাগা দেখোন কেনেকে হ'ব 4 বছৰ তো আপোনাক এটা কপি দিব দিলে
Now, yesterday, my lord,
অ
I submitted an identical order.
not totally matching.
That was in respect of
Any person
Periodic patta.
who doesn't get notified service. Yes, Mr. Sharma, under that proviso section, proviso to subsection 1 of section 8, DLR has power to admit appeal
Yes, Lordship, but
after expiry of appeal period.
your Lordship is relying on a,
Huh?
The main authority, first, the designated public servant is district deputy commissioner.
No, your notification.
no, this is regarding settlement of
Ah,
class and
that's
ceiling
it.
surplus land.
It is there. Yesterday, not,
Yes, Lordship, your Lordship is relying on a notification dated 9/7/2024.
there,
That is
the
regarding,
applicant authority is,
no, that is regarding conversion of allotment of service certificate to periodic patta.
This is another.
This is regarding settlement of khas and ceiling surplus land. In that case, Lordship, most probably this,
okay. Settlement of,
that is a notification, Lordship, of 2022. Here, Lordship, this notification specifically states regarding khas and ceiling surplus land. And if your Lordship comes to the next page, the designated public servant is deputy commissioner.
Hmm.
And in the first page, Lordship, the service name settlement of khas, government khas and ceiling surplus. Here, Lordship, the settlement of khas and ceiling surplus land is carried out by circle officers with the approval from deputy commissioner, SDLAC and department.
then there must be a schedule
Lordship.
that is appellate authorities.
Appellate authorities, yes,
Commissioner, revenue and disaster management.
yes, commissioner and secretary, revenue and disaster management. He has to prefer an appeal before that.
For this service, not DLR. Show it to him. And first appellate authority has the power to condone delay.
Yes.
Yes, my lord, as per this notification, my lord,
Ha.
we will file appeal
Ha.
before the, my lord.
Heard Mr. M.U. Mondal, learned counsel for the petitioners. Mr. H. Sharma, learned additional senior government advocate.
1, 3, 4 and 5.
Assam for the 1, 3, 4 and 5. And Mr. aforesaid, learned standing counsel, revenue and disaster management department, government of Assam for the respond number 2. Post of para. The petitioners, comma, foreign number, comma, have joined together to institute the instant repetition under Article 226 of the Constitution of India. First of, the petitioners have stated that the petition number 1 and 2 are the sons of one late Abu al Hussein. Full stop. The father of the petition number 3 and the petition number 4 are Abu Bakr Siddiq. Sorry, late Suleiman Ali and late Abu Bakr Siddiq respectively. Full stop. The petitioners have stated that their father's name were recorded in the Sita copy Sita copies, comma, dated 28/5/1989 and dated 20/03/2021, 2001, comma, pertaining to a parcel of land covered by tag number 947 within bracket old stroke 473 within bracket new at village Adawari part 2, comma, Thubri revenue circle, comma, district Dhuri, Assam. Full stop. A kacha patta bearing number 121 within bracket old stroke 97 within bracket new for in relation to DAG number 947 old stroke 473 new for the parcel of land measuring 2 kathas and 1 lessa was issued in favor of the petitioners by an order dated 8/7/1992 within bracket 14/8/1992 by the Assistant Settlement Officer, Dhubri Revenue Circle District, Dhubri, Assam. First off. Para. Though the petitioners submitted a number of applications earlier for settlement of the parcel of land, no action seemed to have been taken by the respondent authorities on those applications. First off, when Mission Bosundhara 2.0 was floated or was notified by the state government, the petitioners decided to file applications for the notified public service, quote, settlement of khas and ceiling surplus land for the parcel of land, for settlement of the parcel of land, that measuring 2 katha,
2 kathas, 1 lessa.
total or what?
Total.
Okay, total.
Total.
For all 4 petitions.
All 4.
For the parcel of land measuring 2 kathas, 1 lessa, for in favor of the 4 petitioners on the basis of the earlier, on the basis of the records maintained in the chithas and kacha patta pertaining to the said parcel of land. First off. Insofar as the petition number 1 and 2 are concerned, they submitted their applications number 1, number 2. They submitted their application on 3/12/2022, and the acknowledgement of the application was made by acknowledgement number page 30. Page 30. Sorry, page 29. Huh? Not. Page 28. The applications of the petitioner number 3 and the petition number 4 were acknowledged by the acknowledgement number 29 and page 29. Date to us and page 30. Date to us. Full stop. Para. After submission of the applications, the petitioner waited for consideration of the applications. Full stop. When the petitioners tracked their application status in the designated portal Seva Setu, the petitioner came to learn that their applications were rejected on 9/8/2023, 16/8/2025, and 16/8/2025 respectively for the following regions. Page 31, a box kera didi. What is, Mr. Mondal, something is missing at page 31.
Yes, 30 on.
That box, rejected by CEO on field inquiry, the land is found to have been encroached, I think, in recent years, in organized basis, right? Page 31,
Yes, 30 on.
last box, right-hand side, Mr. Prohibitions,
From the Mission Bosundara,
excluded from the, okay, Malikirish. Similarly, 32, 33. Where? What is this page 34, Mr.?
34 is the Malad affidavit to be filed Malad along with the.
Agreed by
Yes.
a rejection of the application in such manner by the designated public servant, the petitioners, preferred a first appeal under Section 8(1) of the Assam Right to Public Services Act 2012 before the first appellate authority, that is the Director of Land Records and Surveys, Assam, on 20/07/2026, and the Office of the Director General of Land Records and Surveys, Assam, had acknowledged the receipt of the appeal on 27/2026 under seal and signature. Post of. It is the petitioners have referred an instant petition seeking a direction to the first appellate authority, that is the Director of Land Records and Surveys, Assam, to take the appeal referred under 8 within bracket 1 of the Assam Right to Public Services Act for consideration, after pondering the period of delay in filing the appeal, and thereafter to consider the same on merit. Post up. In response, Mr. Sharma learned and Mr. Aforesaid, learned counsel appearing for the state respondents, have submitted that for the notified public service, as per the notification, as per a notification dated 11/11/2022, published by the Revenue and Disaster Management Department, Government of Assam, under Section 4 of the Assam Right to Public Services Act, for the notified public service, quote, settlement of government khas and sealing surplus land, quote unquote. The designated public servant is the Deputy Commissioner, and as per the Citizen Charter annexed to the said notification, it is the Commissioner and Secretary, Revenue and Disaster Management Department, who is the first appellate authority for the notified public service settlement of government costs and ceiling surplus. So they have thus submitted that the Director of Land Records and Surveys, Assam, would not have the authority and jurisdiction to consider the appeal, stated to have been preferred by the petitioners, before him. Full stop. Therefore, the direction sought for by the petitioners in this petition is not called for. Full stop. Para. In this connection, it is relevant to refer to the notification dated 11/11/2022 issued of the Revenue and Disaster Management Department, Government of Assam. Full stop. By the notification dated 11/11/2022, the quote, settlement of government costs and ceiling surplus land has been notified as a public service under the Assam Right to Public Services Act. Full stop. It is mentioned that the government costs and ceiling surplus land in occupation of indigenous people can be settled in accordance with Land Policy 2019. Para. As per the Citizen Charter Annex 2, the said notification, the first appellate authority under Section 8 within bracket 1 for is the Commissioner Secretary to the Government of Assam Revenue and Disaster Management Department. Full stop. Para. Since, as it is found out that the Director of Land Records and Surveys Assam is not the first appellate authority under Section 8(1) of the Assam Right to Public Services Act to consider to entertain an appeal as for the notified public service settlement of government costs and ceiling surplus land, a direction to the said authority to entertain and consider the appeal, stated to have been preferred by the petitioner on 27/2026 before him, is not called for. Post of. Para. The petitioners have canvassed that they have all the eligibility to be extended the notified public service, quote, settlement of government costs and ceiling surplus land. Post of, according to them, they are in possession of the concerned parcel of land since the time of their predecessors in the interest for last 50 years, last more than 50 years. Post of. Therefore, though the petitioner's application, therefore, the petitioner, if they desire to be extended, if they want the service, notified public service, so and so, and are aggrieved by the rejection orders, which they term as non-regent orders, the petitioners can prefer appeal before the first appellate authority notified under section 981 of the Assam Right to Public Services Act, that is the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department, seeking at the earliest, seeking condonation of the period of delay which had occurred in the meantime from the date of rejection of their applications. First of, as per the proviso to subsection 1 of section 8 of the Assam Right to Public Services Act, comma, the first appellate authority can admit an appeal after expiry of the period of limitation for filing an appeal if he is satisfied that the appellant was prevented by sufficient cause from filing the appeal in time. So, therefore, the petitioner, while filing the appeal before the first appellate authority, shall also file an application regarding for the period of delay that has occurred, showing sufficient cause, and if such an application is filed by the petitioner, the first appellate authority shall consider the application for condonation of the period of delay, and thereafter consider the appeal on its own merits and in accordance with law. With the observation made and direction given above, the petition is disposed of. Anything?
My lord, may I pray one, my lord, observation, my lord? Till disposal of the appeal to be filed by the petitioners, status quo as of today.
Where is your apprehension? There is no apprehension. If you
apprehension-
come in a writ petition, if you come in a writ petition, if
Obliged.
you are going to be evicted, come in a writ petition.
Obliged.
Item 19,
If you are really the successor in interest, then you have a good case.
19.
Yes.
May I please, your lordship?
That is also the one item called, that is, what is item 1?
My lord, I am sorry, my lord, I was just coming, my lord, today I stuck up, my lord.
What is item 1? That is here going also. Mr. Bhattacharya was saying,
Yes, my lord, no, my lord, here in the our prayer, my lord, is that we are praying for a mandamus, my lord, may kindly turn to page 36. my
what
lord.
mandamus?
My lordship has taken up one issue regarding this dag number 1702, my lord, at Boragaon, and we are, my lord, praying in this petition that we should
This
be.
is what, khas lane or travel lane?
My lord, it is a 1702 was a, my lord, Exona Patta. Now, my lord, yes, my lord, now that Exona Patta, whether it had been converted by way of a specific order as a Exona, as a khas land, my lord, that is not discernible till date, my lord. So, my lord, we in the, my lord, when we move this petition, my lord, there is an order regarding the status of the land had been passed, my lord, by this honorable court, asking my respected friend to bring the instruction, my lord. A connected petition, my lord, has already taken up and fixed on 26/8, my lord. So, my lord, as notice has not been issued in this petition, my lord.
What is the order passed hearing?
My lord, in that. The order,
4014 of 2026.
Two petitions, my lord. 4014 of 2026.
4083 assuming.
Huh?
No, speaking order has been passed or what?
Yes,
Yes, my lord, the speaking order.
In
had
this
been-
first petition?
No,
No, my lord.
that the connected case one, 4014.
My lord, before the speaking order was passed, this petition was moved, my lord. With the prayer for regularization and settlement of the land in our favor, my lord. And in the subsequently, when the, my lord, My lord.
You earlier approached, this petition was earlier approached.
my lord earlier approached, my
Huh.
lord,
There are a set of directions.
there is a set of
State of directions,
My lord.
right?
my lord. But in those petitions, my lord, we did not pray. For-
Then we will be barred by res judicata, you face.
No, my lord, in the earlier first petition,
Yes,
my lord,
earlier, what are the directions?
my lord, the direction I have annexed, my lord,
Huh.
Page 112.
page 112, my lord.
Now, you cannot do it in piecemeal basis.
No, my lord,
That
in-
one petition you file this time, or next, another with prayer.
no, my lord,
This
in the-
cannot
my
be
lord, in the first,
piecemeal.
my lord, may.
And this has been already disposed of.
Yes, my lord, dispose of, but my
To
lord,
pass
only.
speaking orders.
Only,
Yes.
only with
The
respect. to
speaking
the-
order has been passed.
Pass, my lord. Pass,
Passed.
my
Passed.
lord. That
So
is, that is challenge in this, my lord,
This
4082,
petition.
my lord.
Now, whether you raise that because the issue of constructive res judicata would come in.
No, my lord.
Well,
My
now,
lord,
firstly, let us see the first judgments.
my lord, the
So,
first,
this is praying for some reliefs.
my lord, the relief herein we are
Joined
taking,
together to file about various notices, so and so, they are in possession of various property. These petitioners were the petitioners in the earlier two rounds.
my lord. Earlier one round, my lord, one round, first round.
No, two judgments.
So two orders are there, my lord, two
No.
orders are there. My lord, in those petitions, these prayers were not there, my lord. As per my regarding regularization or settlement of land, only we challenge the notice, my lord, regarding our eviction, my lord. That's why, my lord, we deem that if there is no any prayer is made before my lordships, so there cannot be any direction for our regularization, my lord. And in the subsequent, when the, my lord, this eviction speaking order had been passed, and those speaking order is under challenge, my lord. So, my lord,
No, item number one,
my lord,
they were the petitioners.
my lord, we were the petitioners, my lord.
Now, in the first round, they challenged some notices,
Notice, my lord.
Eviction notice.
Eviction notices, my lord.
eviction notice.
My lord.
And there were directions.
My lord.
At 112.
Page 112, my lord. These directions were issued, my lord, in respect to the notices, my lord.
Now, say direction number five.
My lord. My lord. The district commissioner, Kamrup Metro, shall decide the representations by taking note of the provision of the Assam Land and Revenue Regulation 1886, the settlement rules, as well as the land policy 2019, without being influenced by the contents of paragraphs number 1 and 2 of the said notices so issued, my lord. My lord, there is a direction is there, my lord, regarding land policy. But my lord, we did not pray.
Assam Land and Revenue Regulation.
My lord,
Right.
my lord.
So, if your representation
Yes, my lord.
is
My lord.
allowed,
Regarding settlement or my lord, this.
no, this direction,
Yes, my lord.
is your representation is allowed,
My lord.
meaning thereby you are entitled for
Settlement, my lord.
Settlement.
My lord,
If your representation is disallowed,
my lord.
you are not entitled for settlement under the Assam
Land
Land and
policy.
Revenue Regulation and Assam Land Policy.
My lord.
Is it not in some way
My lord, my lord.
what can be asked directly is sought indirectly?
My lord, that we cannot do before
Huh?
my lordships, my lord. That we
That
cannot
no,
do.
I'll not take the national highway. I'll go by
Bypass, my lord.
bypass this
No,
way, that way.
No, no, my lord.
Can
My
it
lord,
be done? No, I am just
lord,
asking because you are doing the cases. I
lord.
handle one or two.
my lord, my lord.
Is it not land policy?
My lord,
Because
I have done-
another the mandamus
My lord,
is dependent on this issue.
my lord,
Is it not? Assam Land and Revenue Regulation
my lord.
and settlement rules, as well as Assam Land Policy.
Land policy.
These are the three things. One is Assam Land and Revenue Regulation. Second is settlement rules.
One.
And the third is Assam Land Policy 2019. And this representation is to be considered in terms of those.
Those parameters.
If your representation is allowed,
My lord.
meaning thereby you got the mandamus.
It had been rejected.
You will get the mandamus.
Subsequently, it has been rejected, my lord.
So you will derive the right to get settlement.
That is correct.
If it is disallowed, meaning thereby you are not entitled under these three. These are the framework only.
My
These are the
lord.
four corners. So why should we proceed in another repetition?
That is, my lord, that is,
Take a call.
my lord.
I am putting you the
No,
proposition.
no, my lord, if
Take a
that
call.
is, my lord, I am also, my lord, what I have done, I have checked the initial paragraph of this first writ petition, my lord, prayer part. Now, in that prayer part, my lord, we did not pray, my lord, any mandamus for our regularization, my lord, that's
But
why,
what is there
my lord.
already under
yes, yes.
consideration?
But, my lord, this honorable court in para 5, that clause 5, it had been directed to consider our representation to that extent also.
Yes.
So therefore, my lordship's query, my lord, it required some consideration. If it is, writ petition also may not become maintainable also. So as the subsequently, my lord, speaking order has come up, my lord.
For these petitioners.
Yes, yes. my lord.
Yes, yes.
That is, I mean, that writ petition, my lord,
They are protected by an interim order.
my lordship has protected us, my lord, because we are now, my lord, directed to evict within a 15 days, my lord.
This is the 4041.
Yes,
My
14.
lord, my lord.
4014 and 4083.
83.
Okay.
These two lordship
My
has
lordship
protected them.
Last year.
And what is the prayer made there?
My lord, only for quashing of this, my lord, speaking order, my lord.
But is it not directly or indirectly?
Because, my lord, now. if
This direction you have sought in the here
My lord,
is to issuance of writ mandamus.
my lord.
Now with the finding,
Finding in the,
unlike that finding is unsettled.
my lord.
This goes.
Because, my lord, our prayer for this regularization in our representation as well as the earlier direction, my lord, has been rejected by way of this speaking order, my lord. Now, we have challenged it. Now, if my lordships consider that this speaking order is bad in law, my lord, then we will get the relief. Again, it will come back to us, my lord. That's why, my lord, as in this present
This
petition,
is a multi-pronged,
now, my lord, cause of actions.
cannot be, because
Slight-
all three, your case is wholly dependent upon Assam Land and Revenue
Right.
Regulation, settlement rules,
and land
and
policy.
land policy, and all other notifications are subservient to all this.
Yes, my lord.
Whatever notification is there, it is only under them. Because state government also cannot go beyond Assam Land and
No,
Revenue
no.
Regulation. So in a way, it is
But, my lord, if we do not pray before my lord, then question may come that where is your prayer regarding regularization? That question may come, my lord, in due course.
so. In your representation, what did you do?
My lord, the representation part, my lord, we have annexed, but that has been rejected, my lord.
Right, that is page 112,
Yes, yes,
direction 4,
yes. 114, my lord.
page 112, direction 4 by the coordinate bench.
Yes, my lord.
that representation is to be considered strictly in terms of so and so, so and so, and so and so.
Yes.
Meaning thereby you are either
Direction.
entitled or not entitled.
Now they have said I am not, we are not
And
entitled.
So in that case, in the face of that,
Fresh writ petition will.
in the face of that finding,
Mal.
in the representation by the fact-finding authority,
Well,
because that authority has been given, say, by the Supreme Court also,
mal,
in a way, right?
mal.
That they have to find out, thereafter you have the remedy.
And in page
don't
112,
know.
my lord, paragraph
I don't
4,
know for what reason there.
there is a direction for consideration of their
Whether these
representation.
petitioners
Yes.
have preferred any other petition.
This-
Item number 1.
Yes, yes, they were the.
4014 and 4083.
83, my lord. Subsequent to, along, my lord, including this, they are now 3 petitions they have preferred before this honorable court.
We'll put it then along with them.
My lord can.
Maybe closed, my lord, in view of the subsequent
No, no,
development.
no, in that.
And they are protected also. That is why, my lord.
No, we are not for protection part, my lord, is there, but my lord, we have not made a prayer because as this petition is pending, my lord.
No,
the
in
subsequent-
paragraph 1, in paragraph 4 of 112, my lord, lordship may kindly see, there is a direction to consider their representation also. Representation includes their claim for regulation. So if the ultimate speaking order is passed, and that is agitated in those
Okay, it
petitions,
will be decided, we'll put it
26,
here.
on 26.
Heard Mr. A.R. Bhunyal and senior counsel listed by Miss S. Law Court petitioners. Are you sure they are petitioners in the
Yes,
other one?
Yes, I have checked.
Yes, ma'am.
Yes.
Yes, ma'am.
They are the only ones?
Yes.
Yes.
Because some others are also
No,
there.
no.
2 petitions were filed, my lord. In those petitions,
Here it is 18.
18, my lord.
And in those 2 petitions, total is 18?
Yes,
or-
18, my lord.
Okay,
18.
otherwise 50 more.
No, no, in
Then
4014.
I'll throw all these petitions.
Yes,
No, no.
Out.
My lord,
Right.
my lord, as. if-
Because it's very
my lord,
difficult.
if my petitions are dismissed also, my lord, then
No, no, no.
I cannot, my lord, make a false statement, my
No,
lord.
no, I'm saying that
My
is
lord.
why to ensure that these 18s are the 18s there.
Yes, yes, my lord.
That's all.
Yes, my lord. Yes,
That is one.
yes.
And thus,
No, no, it is a valid-
1, 3, 4, 5 and 6, aforesaid, revenue 2. The Learned Counsel for the parties have submitted that these
আছে, আছে। 408
petitioners have
882
also preferred
मेरा काम
2
करो,
writ
डायरी बना
petitions.
लो।
WPC number 4014 and
4083.
83 to assail
জাহানারা বেগম তো।
a subsequent cause of action. And in those writ petitions, notices were issued returnable on
26/8, my lord।
26/8/2026. Let notice be issued in this case also. The notices are made the notice is made returnable on 26/8/2026 as so and so has appeared, accepted, extra copy, you need to work in this. This is the case on 26.
My lord, my lord। Obliged, my lord।
So interim order is operating there.
There we are protected, my lord।
We'll come back.
May I please, your lordship? My lord, in this petition, my lord, we are challenging an speaking order, my lord, is at page 147. Series of speaking orders, my lord, individual had been passed pursuant to a direction, my lord, passed by this honorable court.
One,
Page number 147, my lord, Annexure 8, Holy, my lord.
Prior to that, Lordship, may I submit something? There are altogether 77 petitioners, and they have annexed only 5 or 6 rejections orders. And all the rejections order are passed individually. And in one a rejection order, I never found subject to correction, Lordship. I have not find his name in the in the petitioner's list, Lordship. So, Lordship, without annexing the all the rejections orders, whether the other petitioners can approach. One 47 page number, he is petitioner number 45. 148 65. 149, I have not found his name in the list of the petitioner subject to correction.
now right to settlement is an individual right, now separate, though orders are passed on the same date. 77 petitioners, some of them might have the better right than others.
No, my lord, we are
How?
equally at par situated, my lord.
No, the documents submitted by
My lord,
petitioner
my lord.
are different and considerations are given accordingly.
My lord.
How is it possible to
Club.
decide each of the 77 petitioners' fate
In one petition, my lord.
in one petition?
My lord.
Only on the only on the question of law, then it is okay.
My lord. But facts are,
If the facts are different, it is up to you.
my lord.
If you confine yourself to question of law, it is possible to decide. But say 147, he submitted 7 number of documents, which are his representation.
My lord.
Next is 5 number of documents. Next is 6 number of documents.
My lord.
And similarly, 5 are annexed.
No, my lord,
How can we determine the individual rights of the petitioner? These are individual rights. All right. Earlier, the cause of action was
eviction.
common notices similarly worded. Similarly worded. But here now it is an individual cause of action. If common question can be question of law.
Question of law is, my lord.
That can be decided.
That can be.
If you say that you have a common cause of action, then that will be question of law only.
My lord.
No individual,
Rights.
no individual adjudication.
Adjudication. That will be difficult, my lord, because individual adjudication is
On the basis of that, one person may have a better claim,
yes, yes.
the other person may not have any claim. Somebody has submitted 7 documents, somebody might have the, and those documents would be different.
It appears, my lord. From
And
this
how
report.
can we establish the linkage for each of the petitioner when you have annexed only 5 or 7 or 10 and 77 petitioners?
No, my lord, we can bring all the my lord.
No, how? No, you have to think about the code also.
Because, my lord, for our wrong, they may suffer, my lord, subsequently.
Oh, code will go as a whole common facts on common question of law. And these are fact finding.
Fact finding, my lord.
We can proceed on that basis. Certiorari jurisdiction.
It is very narrow, my lord, then. Well,
will not have the occasion to decide individually.
My lord.
Finding of fact, unless it is perverse. And let us see one at least. Because since your right
My lord, one,
right for settlement is involved, hearing was conducted during the hearing process.
my lord, one very important aspect.
Let us see one,
my-
at least read one.
My lord, in
If in page 140, as your lordship gone through the page 147, serial number 2, the document regarding the documents, as the given address of the petitioner is different than the land he is currently encroaching upon. The landless status of the petitioner could not be ascertained as the residential details submitted by him is beyond jurisdiction of Sonitpur district. Whether this factual aspect can be determined in a writ court, lordship. Then voter ID also, lordship, belongs to different place. Petitioner নহয়
কোনোবা বাপেক নে কোনোবা আছে?
149.
আব্দুল লতিফৰ পুতেক হয়।
They also approached earlier.
Yes, yes, my lord.
These petitioners?
My lord, even some of the petitioners, my lord, approach the honorable apex court also, my lord. There is a direction of the honorable.
Where is
apex-
that?
Yes, yes, my lord. My lord, may kindly find that order, my lord, is at page 116, my lord.
They had a petitioner or
Yes, yes, my
somebody
lord.
else?
Petitioner number 1 to 27 in this petition, my lord, where the petitioners in this that SLP, my lord, similarly placed, my lord, situated. And my lord, in this order, there is a direction had been issued at page number, my lord, 119, my lord.
142 are aggrieved by the judgment and another. They are from which district?
Sonitpur, my lord. Sonitpur district, presently. And my lord, this land of 220 acres, my lord, has already been acquired. And the paddy field wherein we were, my lord, cultivating has already been acquired, and we are no more being permitted or allowed to go. Now, this land wherein we are residing, my lord, is the subject matter of these petitions, my lord. Wherein the honorable apex court has said, my lord, in last paragraph,
Notices 15/11/2000.
direction.
How many petitioners here?
Here, my lord, 77, my lord.
Initially, there were about more than
Yes, my lord.
207.
Yes, my lord.
Hmm?
My lord, litigation before
207.
this honorable court, my lord, in WPC 1083, that is Kalicharan Mandal, my lord.
10
Uh-huh.
or 8309.
Yes, my lord, 1083 of 2025 is the first petition, my lord, before this honorable court.
Where is the order?
Page number 86, my lord.
No, what is 48 then?
Page number 48, my lord, is
Mr. A.R. Bhuya, Senior Counsel, tested by Mr. S. I. Hussain, petitioners. H. Sharma,
3, 4, and 5.
additional senior government advocate, Assam Party, respond number 1, 3, 4, and 5. Mr. aforesaid, revenue 2. Para, in this writ petition, 77 number of petitioners have joined together, stating that they have a common authorization. So, para. On 15/11/2021, the circle officer, Hekiazuli Revenue Circle, issued eviction notices for alleging that eviction notices to notices stating that the notices had unauthorizedly occupied plots of land areas of land, mentioned specifically in those notices, under DAG number 91 of number 3 Sitolmari village, Moja Borsola, Kekiajuli Revenue Circle, District Sunipur. Post. Against those notices, dated 15/11/2021, 207 number of notices joined together as writ petitioners to file a writ petition 8 WBC number 8309 2022. Post. Apart from assailing the eviction notices, the petitioners, 207 number, had also sought for a direction that the areas of land under their possession should be settled by the respondent authorities in terms of the Assam Land Policy, 2019, on the premise that the petitioners were indigenous landless persons entitled to settlement. Full stop. Para. It is the said the said writ petition was disposed of by a judgment and order dated 18/12/2024 with a set of observations and directions. Now, 17 in the following manner. Page 73. To 70. Person to the judgment and order dated 18/12/2024. The District Commissioner Sunit Kaur. What is the direction? Page 76?
Lord, the page 76 direction has been issued lastly. Lord, the.
I've also sought for a direction to so and so under to be settled by so and so if their engineers.
My lord, at page 81,
Observed in notices for eviction, there is no material placed
One
before
of
so and so. And order maintain that the court cannot be unfindful of the right of the government in respect of so and so. So and so, further observed the directive. This is seen the project report, right, so and so. Seen the petition submitted, all the petitions, heard all the so and so during his petition submitted several documents in support of subsequent amount of time will be declared. This party to mind. The outer book, the interest of express completion is predicted that order dated, order question date 1 on 1/2/2025. First of the operative parts of the order dated 1/2/2025. Read as under page 79 or. It is party then, huh? It is party. So 220 across gone.
Yes, my lord. Now,
Just a
Lord-
minute, we are going
Yes, yes,
sequentially, we
yes,
are
yes.
going sequentially.
yes, my lord.
By this order only.
Mm,
As given, the petition. The order dated, next paragraph, the order dated 1/2/2025. Deemed to be challenged. Again. By 175 number of
my lord.
persons as read petitioners. Out of the original
Two.
207
207.
number of petitioners in a writ petition. 1087
1083.
stroke 2025.
1083, my lord.
1083.
Page 86.
Also. After hearing, the writ petition was disposed of by an order dated 12/3/2025. Page 86, sir, 107 of the. Taking into consideration the observations and directions made in the judgment and order dated 18/12/2024. And the order dated and the contents of the order dated and the directions and the contents of the order dated 1/2/2025. The court had observed that the impugn order
Certain directions were given at page 109 onwards. 109. Accordingly, the instant writ petition stands disposed of with the following observations. There are total 11 observations.
No.
that is
No,
of the earlier one.
Lordship,
one-
your
Earlier
lordship.
one.
Earlier one,
Yes, lordship.
Reiterate.
Regarding that 100,
That already I have quoted.
lordship.
Direction in this case, my lord, is at page 114, my lord. In the considered opinion.
The court allowed the district commissioner to pass a fresh order strictly in terms of the judgment and order dated 18/12/2024, passed in WPC number 8309/2022. Full stop. In addition, the court had made the following observations. Page 114, para 13. Fourteen, 15, 16, 17. In the considered opinion of this court, proposal of APDSL is equitable proposition inasmuch as the Deputy Commissioner has referred him has already directed that and to defy the families or enforcing government land by constructing houses and shift houses temporarily. Whereas if the temporary will be taken up together with another person. Start their so and so subject to the condition that shall not be evicted until they are shifted temporarily to any current. Para 13 to 18. Para. Agree by. The order dated 12/3/2025 passed in WBC number 1083/2025, comma 143. Petitions approached the Honorable Supreme Court in special leave to appeal within bracket C number 8330/2025. The said SLP was disposed of by an order dated 26/3/2025. With the following terms. Individual notices were issued to persons were allegedly dated 25/5/2026. Were issued to persons who were allegedly in unauthorized occupation of different areas of land under DAG number 91. Number settlement village, asking the notices to appear before the office on the cycle office revenue cycle within a period of 15 days therefore to file objection stroke representation along with all the supporting documents in respect of their individual claim regarding their eligibility for settlement of the land. Full stop. Where it transpires that after the notices dated 25/5/2026. "77 number of persons had again approached this court by a writ petition WBC number 3073/2026, assailing the notices dated 25/5/2026. Post of after hearing, notice was issued to the respondents on 10/6/2026. interim. In the interim, it was provided that till the returnable date, within bracket 25/6/2026, the petitioners therein shall not be evicted from their dwelling houses pursuant to the notices dated 25/5/2026. Full stop. Para, it is in after the above events, comma, individual orders were passed by the circle officer determining the claim of the notices. Full stop. The orders were passed on 20/06/2026. Full stop. Para, out of the 77 number of petitioners joined in this writ petition, comma, only copies of only eight orders passed in respect of the petition number.
I am placing lordship. 147 is petition number 45.
As annexer,
Annexure.
annexer,
Eight poly.
series collectively, 8 poly. Full stop. On examination, it is found that the notices the orders pertaining to petition number, yes,
45,
45,
65, then lordship 38, then 51, 46, then 60 and 64.
are only annexed.
Regarding page number 148,
Full stop.
This
It is submitted.
lordship, not 148, 149, this person Bahrul Islam is not before your lordship. And I have been told that his father has come, but lordship, the notice is issued to the son. Page 149. Third line, Baharul Islam. He is not before your lordship.
By the orders dated 20/06/2026 passed individually to each of the notices, comma, the claim of the notices regarding his eligibility to get allotment stroke settlement of government land under DAG number 91. Government land at number 3 Sitolmari village was decided in a negative. And the notices have been directed to free the government land under his encroachment, failing which necessary action would be undertaken as per existing law and procedures. Close to. Para. It is these orders, comma, dated 20/06/2026, comma, issued to the 77 number of petitioners, out of which only 8 of the orders are annexed to the petition.
One is
Comma.
not before your lordship. One is not before.
Eight.
your lordship.
That one objection, my lord, is. issued
8.
to the storm.
I'm saying 8.
Ma'am.
Are under challenge. First of Mr. Sharma, learn it. Yes, what is your case on these notices? Now I'm
My lord,
complaining now.
My lord.
77, then 8. We'll decide at a later
My
point
lord,
of
the
time.
issue is that the speaking order, my lord, which had been issued, was required to follow the direction initially passed by this honorable court, as well as the, my lord, direction of the apex court. That, my
What
lord,
direction?
my lord, the direction of the apex court was that before our, my lord, displacement or shifting, My lord, if just for a moment, my lordship may be pleased to take up paragraph at page 107, my lord, page 119. The direction was.
107.
No, my lord, page 119, paragraph 7 of the Apex Court direction, my lord. Page 119, my lord. There can be no reason to doubt. And we reiterate so that though the respondent number 5 corporation is at liberty to commence the establishment of the solar project within so and so acres of land in question, however, the petitioners shall not be evicted from their dwelling units till they are shifted temporarily to any government khas and ceiling surplus land in terms of the decision already taken by the district administration. So, my lord, admittedly here before my lordships, my lord, all those persons who approach the honorable Apex Court is not before my lordships, my lord, but they are adjacent to the same area and same village, my lord. Now, 24 persons were there, my lord, before the Apex Court, 27 persons, my lord. So, therefore, my lord, this part that
Before
the-
the Apex Code, there are many, 143.
my lord, the 143 order, my lord.
Now,
the-
first, it flows from
my lord,
the original direction.
original direction of this-
Original direction
Yes,
is
yes.
that upon hearing the district commissioner shall pass appropriate order to the effect that as to whether the petitioner or the other persons who have submitted the representations are indigenous landless families of Assam.
my lord.
Right, on the
My-
basis of the said opinion, district commissioner shall pass appropriate order allotting certain specific area of land to those individual landless families from the land earmarked in DAG number 378.
My lord.
This is the original
Order, my lord.
order,
My lord.
right?
My lord.
So, first issue is to be determined whether individual landless person or not
My lord.
eligible. Then they are to be allotted certain specific area of land, meaning thereby are those who are found to be not indigenous landless person are to be excluded out of consideration.
Exactly, my lord.
This is the part of this order,
Purport of
perhaps.
this order, my lord.
Whether this has been diluted
No, my lord, that.
by
it-
any manner by Supreme Court or by the subsequent order.
No, my lord, it had not been diluted.
Diluted.
My lord, my respect.
So-
My lord.
What is to be decided first?
Indigenous or not, my lord.
So,
My lord.
by this order, what has been decided?
By this order, they have said that only we are, my lord, habitual encroachers. If my lord may be pleased to take
No,
up the
where
findings.
there, there the question comes.
My lord.
Land document.
Yes, my lord. Land document is there, my lord. Land document, they are required.
No land document pertaining to allotment so and so, so and so. It is recorded in page 147.
My lord, may I read the operative part of this speaking order, my lord? Whereas it has been said, my lord. The
Operative part has to be read with the other part
other
also.
documents, my lord.
So
my lord.
your documents are 6, 7.
7, my lord.
What are those documents?
My lord, it has been said that the voter ID, Aadhaar card, ration card, legacy data, FPTCL bill and land documents. It is found that no land documents pertaining to allotment oblique settlement of land at number 3 Sitalmari is submitted by Jahid Ali. My lord, we do not have. We are the landless people residing therein, my lord, in those areas long
No, finding
back.
is different, sir.
My lord,
Findings, see, Mr. Bhuya,
my lord. my lord.
every person's finding is different,
That is correct, my lord. That is
right?
correct.
So we'll record his objections.
Yes, my lord. My lord can, my lord.
Then thereafter, question of maintainability will be kept open.
Uh,
That this is court's view.
No, my lord, with all respect, my lord,
Obviously,
my lord.
Whether 77 persons by annexing 8 individual orders.
No, my lord, we
state
can.
No, no, that is up to you.
My lord,
But I have to observe that we'll keep this
Uh-huh.
maintainability issue open because he has raised the question.
Lord, in paragraph number 29, we have, my lord, stated that why all these document has not been annexed, my lord, in this petition. That
No,
it
we'll
was-
decide
My
that 77 number of persons
my lord,
can have a common cause of action
can club together.
where individual orders based on documents submitted with the representation
Are different.
can
my
be decided in a petition. That is also a
lord. No, my lord,
question of procedure.
I have to bow down my lordships any observation,
no,
my lord. But my lord,
I will keep this issue open.
My
I
lord.
am making it clear because he has raised the
no, my
objection.
lord, that can be,
I have also found there is some force in his submission.
yes, yes.
It is not that only petitioner's submission will have force.
No,
Other
No, my lord.
respondents can have force.
my lord.
So I find some force
No, my
in their
lord,
submission.
my lord may be obliged.
Serial number 147. As the given address of the petitioner is different than the land he is currently encroaching upon. The landless status of the petitioner could not be ascertained as the residential details submitted by him. Maybe lordship thereafter, lordship, after passing of this order, some other persons are encroaching also.
Mr. Sharma, yes, Mr. Bhuyan as senior counsel appearing for the petitioner has submitted that. Yes. Which page?
My lord.
The individual orders are not in conformity with the observation made by the Honorable Supreme Court in paragraph 7. 7?
9, my lord, paragraph 9.
Paragraph 7 of the Honorable Supreme Court of India?
Yes, yes.
Paragraph 7 of the order dated
Yes, yes, sir.
26/2025 of the Honorable Supreme Court in SLP number 8330/2025. Yes, one submission. Next
On
submission.
submission. Then, my lord, this speaking, my lord, the order in which it has been said, my lord, in this speaking order, there is an original direction of this honorable court as well as the deputy commissioner has assured that the whether these people belong to the indigenous category or not, that will
There
be
is no
determined.
determination
My lord.
in the individual orders whether the person concerned is an indigenous,
My lord, or not.
landless person or not. And therefore, the individual orders are suffer from the infirmity and not in conformity with the observations and directions made by this court in its earlier orders and the Honorable Supreme Court of India. Post of Mr. Sharma, learned edition, and Mr. Aforesaid, learned State Council appearing for the official response, state respondents have submitted that in this petition, 77 number of petitioners joined together stating that they have a common cause of action. Post of, however, the circle officer, Thekejuri Revenue Cycle, has passed individual orders in respect of each of the notices were served. The notices, dated 25/5/2026. Full stop. Each order was passed based on the representation submitted by the notices separately and the documents submitted by the noticee, each of the noticee in his individual representation were considered separately, and thereafter the individual orders were passed. So in such view of the matter, the petitioners 77 number, cannot have a common cause of action as the orders, dated 20/06/2026 are passed based on individual facts pertaining to each of the notice. So moreover, the individual orders passed in respect of the remaining 69 number of petitions are not made part of the writ petition, and therefore those orders cannot be examined in this writ petition. First of all, only a question of law can be examined as a common cause of action, not the determination of facts arrived at by the circle officer so-and-so, revenue circle, in the individual orders dated 20/06/2026. The contentions advanced by the rival contentions advanced by the parties would require a detailed consideration, issue notice returnable on so-and-so. As so-and-so has appeared accepted. Issuance of formal notice to the respondents is dispensed with. Extra copies. Consider its entirety and for balancing the equities, comma, it is observed that the status quo as of meaning today in respect of the areas of land concerning this 77 number of petitions are to be making. till the
9th September,
Deeply obliged.
0909.
The issue of maintainability of the writ petition is yet open for consideration at an appropriate stage.
My lord, may I take the leave of my lordships to bring other?
You seek leave in writing,
My lord, obliged.
no oral writ. After giving so much consideration
My lord.
for 1 hour,
My lord.
it should have been at first at the beginning,
My lord.
otherwise in writing.
My lord.
No such concession.
My lord.
69 number of petitioners, you know the fate.
Obliged.
We cannot examine their case. Rest assured.
Obliged. Deeply obliged.
Timing matter, item 16.
Yes, sir.
What's it in this case, I have obtained instruction from the IO. What's the issue is that could not complete the search and seizure in absence of the petitioner. What's may provide that they will cooperate with the search and seizure search and we'll open the promotional.
Otherwise, this issue is before Supreme Court today at 2 p.m.
What's it, I'm not available.
You don't know. It is Murliwara pigment. Rajasthan High Court has exactly same issue, 67-4 sealing
Achha.
of premise.
Lots of here, lots of no seizure has been, no seal has
No,
been.
same thing.
Lots,
6 premises were sealed
lots.
because he was not there. Is it not? At 2 p.m. today.
Yes, then I charged it and then I found that.
Lots of here in this case, lots of may dispose of the writ petition.
Hard.
Direction that petitioner will.
If you
cooperate.
cooperate,
Yes, sir, we will cooperate, my lord.
Today itself, lots at 4 o'clock.
4 o'clock.
Lots.
I
My instruction is that they will immediately, they will.
today.
follow that time.
Tomorrow 11.
Lots,
Yes, my lord.
Tomorrow 11
lots, Lot-
a.m.
lots.
Petitioner will
Yes,
be present, shall be present at the premises, sealed premises,
Lots.
2 premises.
Two
Yes, ma'am.
premises.
So he
in the
cannot be
same-
present?
In the same
In
building.
the same building.
Same building?
Yes,
Lot.
ma'am.
Okay, heard Ms. N. Gogoi, learned counsel for the petitioner, and Mr. Union? Anybody union?
Nobody is there.
Mr. S.C. Kyle, learned senior counsel and special counsel, CGST, assisted by Mr. K. Jain, learned counsel for the respondent number 2 4,
Let's see,
5, 6, and Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation Department, Government of Assam, for the respondent number 3. Full stop. Para.
see, इसका photo ले लो तो.
Will not record much.
Lordship. Simply Lordship.
The petitioner was served. A petitioner was on 25/7/2026. The petitioner has been served with 2 orders of prohibition in form GST INS-03, whereby the petitioner's office premise at Siam Complex, Diwal Road, Jorhat, Assam, PIN 785001, and his residence at the same complex
Yes.
are sealed on the ground that when after an authorization under section 67 within bracket 2 of the Central Goods and Services Tax Act 2017, the team of officials led by the authorized officer visited those premises on 25/7/2026. Those premises were found locked. Full stop. According to the respondent authorities, attempt was made to contact the petitioner telephonically at his mobile number to inform him about the search authorization and to open the premises. Full stop. It is mentioned in the prohibition orders that the petitioner did not respond to the calls, rendering it impracticable for the team of officials led by the authorized officer to gain entry into the premises for executing Form GST INS-01. And it was in such backdrop, the prohibition orders under prohibition orders have been passed by for sealing the premises of the petitioner under exercising power under section 67 within bracket 4 CGST Act read with rule 139 within bracket 4 of the CGST rules 2017. First stop. Para. Assailing the prohibition orders, said to prohibition orders, the petitioner has approached this court by the present writ petition and the Article 226 of the Constitution. First stop. Para. In the writ petition, the petitioner has refuted the ground, has sought to rebut the grounds mentioned in the orders of prohibition by the respondent authorities, CGST authorities. Full stop. Be that as it may. Full stop. Mr. Next. Mr. Kyle, Senior Counsel. and Special Counsel CGST appearing for the respondent CGST authorities has submitted that if the petitioner cooperates with the process of with the search proceeding by appearing at the sealed premises at 11 a.m. on 5/8/2026, then the premises will be desealed and the search proceeding in terms of the authorization dated 25/7/2026 will be carried out by following due procedure. Full stop. Para. In response, Ms. Gogoi has submitted that the petitioner is ready and willing to cooperate with the search proceeding proposed to be carried out in terms of authorization dated 25/7/2026 issued under section 67(2) of the CGST Act, and therefore the petitioner would appear at the premises at the two premises, which are in the same building, at 11 a.m. on 5/8/2026 positively. Full stop. In view of the broad consensus arrived in view of the broad consensus arrived at by the learned counsel for the parties in the aforesaid manner, instead of keeping this writ petition pending, the same can be disposed of with a direction to the petitioner to be present at the premises, at the two premises at 11 a.m. on 5/8/2026. In such, on his appearance, the respondent authorities shall deseal the two premises and thereafter shall carry out the search proceeding strictly in terms of the procedures laid down in the CGST Act 2017 and the CGST rules 2017, and the extent full stop. It is accordingly ordered.
Much.
Whenever you get this Murliwala pigment,
Lordship, I'll teach out.
please place the copy of the order,
Lots,
because Rajasthan High Court said no writ petition,
lots,
not maintainable,
lordship, I've seen the.
right? Go and
Following rule 140 and 140.
go and take appropriate action. Now, Supreme Court has taken cognizance. It may give some observations also. Accordingly, we will decide.
Lots.
There will be many other.
For hearing,
My lord, before lordship starts the hearing, my lord, we have a matter item number 2 to 5. Perhaps the matter is fixed at 2 p.m. before your lordship.
Yes.
So may I pray for a date in respect of item number 2 to 5? A joint prayer is there, my lord.
Some file too. Okay, T Chakraborty. Petitioner Sekita, for the private respondent. U does. D does is there. D does. Present as sought for. And agreed to well and for the parties. This is the case on. Cases on. File
September. 8 September. 8, 9.
interim orders wherever past earlier shall continue.
Ishwar
2 to 6 or 2 to 5.
10 September. 10 0.
interim order.
What? Obliged.
Items 10 and 11 for hearing.
6 is available, Mr. Google.
Item 6.
Thursday we'll try. 6. Google. And spending council revenue. Government advocate, government advocate are present, huh? This is the case on Thursday.
My pleasure, Lordship. Look, in this case, on the last occasion, your Lordship asked me 3 questions.
I forgot.
Probably it is written, I am told. लिखा समझे?
Not,
तुम्हारा लिखा समझ नहीं पता? हाँ? Oh, your Lordship, in the note of your Lordship, I am told, basically 3 questions were asked.
not sure.
All right, I am telling you. Question. First question was that when the Supreme Court has declared that equal pay for equal wages shall be applicable to the minimum scale of pay, then why should we give them higher wages? Probably your Lordship relied upon the judgment, State of Punjab versus Jagjit Singh.
Oh, I indicated.
Yes, your Lordship indicated me. 2017, 1 SSC, page 148. This was the
2017.
1 SSC, page 248, 148.
Jagjit Singh.
Jagjit Singh, yes. Your Lordship asked me this question specifically. Yeah, when the Supreme Court has passed this order, then why you shall give the higher wages?
Yes.
Second question was that basically this case is governed, so far our case is concerned, this case is governed by the conciliatory settlement. And when there is a conciliatory settlement, it will be binding to all. Whether you are a party to it or not, that is immaterial.
If I remember correctly, that these two or three unions.
There was a conciliatory settlement.
With two
or three unions where though we are not party, but as it is a conciliatory settlement, it is binding on us. As it is binding on us, why we shall invoke these provisions? That was the question posed by your Lordship to me.
Yes.
Third question was that the Deputy Labor Commissioner, while fixing the wages, he has
added two components.
Hmm.
One is 5,000 and other is 3,000. What is the basis of adding these two amount, my lord? These three questions your lordship asked me, my lord, to answer, my lord. Now, today I shall try to answer at least as first question first, my lord. So far, those cases are concerned wherein daily wages or casual workers were given minimum scale of pay while comparing with the grade 4 regular employee. That there is a series of cases. Now, my lord,
No. Perhaps. Jagjit Singh, I asked that Jagjit Singh, various judgments,
all judgment, almost all.
judgments
Yeah.
were discussed.
Yes.
And there are a number of factors
Yes.
for equal pay for equal work.
Yes.
Where
Considered.
would fall for consideration.
Yes.
Right. No, I don't think at
Yes. You are absolutely correct.
So those factors are to be examined.
Examined. Yes.
Right. And by that is a domain of the experts.
Yes, but
in the field. And court is not in a position.
yes.
But while the experts, even if we accept that Deputy Labour Commissioner is the expert, he had to take all those
these
factors.
Yes. That is your
to-
lordship.
I think that
That
perhaps
is-
was
yes.
the
Yes, exactly. What is your
not at the minimum
Yes.
scale of pay.
What is your lordship's mind?
Not
that
on the not
all
on
the
the
factors which
that
were
casual worker, daily worker, not on the concept of casual worker or daily worker. It is regarding the factors to be taken into
yes, factor to be considered
for equal pay.
pay for equal wages.
That is what I think.
Yes. That's hard to control. What is factors to be taken into account? What are these factors? This is probably your lordship's query to me. Now, my lord, so far this case is concerned, all those cases, before going to the judgment, my lord, let me try to clarify to my best.
Here, I think question is regular workers vis-a-vis
The casual workers
casual workers.
and daily wages earners, etc. These are the questions. So, in these questions, all these cases were examined. Now, the basic principle that was considered here is Article 39D.
What is Article 39?
39D. Without going to the judgment, let me try to clarify to some extent. Lord. Certain principles of policy to be followed by the state, A, B, C, and D, that there is equal pay for equal work for both men and women. You got it?
Yes, underlying concept is different perhaps. It is equality of pay for men and women.
No, for all. Equal work for both men and women. Now, my lord, your lordship come, kindly come. Article 37. May I read now?
Yes.
Application of the principles contained in this part, that is directive principles of the state policy, that is at part 4 of the Constitution. The provisions contained in this part shall not be enforceable by any court. So, these provisions, that is Article 39D, is not enforceable for any court. But the principles herein laid down, nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So far Article 39D is concerned, there is no such law till date. But these principles was applied in the case of Article 14. Now, my lord, Supreme Court, in a number of cases, they have reiterated that straightway you cannot pay equal wage to a casual worker. There is a reasonable classification between these two classes. One is regular employee and other is casual workers. In a number of cases, my lord, it has been decided that their source of recruitment, process of recruitment, responsibilities, all these factors are to be considered. And if all these factors are identical, then and then only equal wage for equal pay is applicable. At initial stage, my lord, it was mechanically applied. But in the subsequent cases, my lord, Supreme Court pointed out. All these cases have been referred, almost not all, almost all these cases have been referred in this 2017 1 SCC 148. Now, my lord, in Umadevi's case, my lord, it was a problem, the court, how to implement this thing. In Umadevi's case, my lord, at paragraph 55, that is a direction made under Article 142. This is also discussed in this Jagjit Singh's case, my lord. The direction given in the Umadevi's case at paragraph 55 is a direction under Article 142 to resolve these issues. To resolve this issue as because there is no such law. And that is also clarified by a subsequent case that is reported in 2009 9 SSC, page somewhere. And this case also referred in this Jagjit Singh's case. And ultimately, by referring all those cases, this Jagjit Singh case also applied Article 142 and give these directions. That will be my submission before your lordship. But so far our case is concerned, we have a law. This law is Rule 25 to 5A of the Contract Labor Regulation and Abolition Rules 1971. So that is the basic difference. We have our law, and here it will be mechanically, it will be applicable. Physically, it will be applicable. And this aspect of this case was also considered by the Supreme Court in at least two cases. One is Vale Workers Union. That is, just I'm giving my guideline a principle. That is Vale Workers Union 1985. 1985, 1 SCC, page 630, at paragraph 6. And other case, that is chemical Mozdur, no? It is 2018, 18 SCC, page. Hmm. 2018, 16 SCC, page 25. These two aspects of the case was considered at paragraph 5, 6, and 7. Sorry to hold up now. That was in 1985. It was a 2018 volume 16 SCC, page 25. Relevant paragraph 5, 6, and 7. Today, Millard, I shall try to explain this matter. Now, Millard, let us. So, my senior counsel has referred this judgment, and copy of this judgment is with your lordship. 2006, 17, 1 SCC, page 148.
Yes. Judge Singh.
Judge Singh. So let us, the case they have referred, I will go through that case first. Then I will proceed my case. Now, so far Jagdish Singh's case is concerned, after discussing a number of cases, I will, for the timing, let me skip it up. Straightway, your lordship can come to paragraph 37. Yes. Paragraph 37 page, relevant page is 201. All these cases were discussed. 37, okay, same as well. Paragraph 37. Page 201. SCC. Okay, yeah, 201 আছে।
37. Yes.
201, paragraph 37.2.
Yes.
Now, in this case, their lordship have referred the case State of Haryana versus Charanjit Singh. 2006, 9 SCC, 321. Now, your lordship may kindly come to paragraph 37.2. They have quoted. I will not refer this 2006 because it is quoted here at paragraph 19. Having considered the authorities and submissions, we are of the view that the authorities of the state authorities in state of Haryana versus Jamshed Singh, state of Haryana versus Tilak Raj, Orissa University of Agriculture versus Mohanty K. Mohanty, and state of West Bengal versus Torun Kumar Rai lay down the correct law. Undoubtedly, the doctrine of equal pay for equal work is not, it is very much important, is not an abstract doctrine. This may kindly be noted. Abstract doctrine and capable of being enforced in the court of law. This is Article 37. Doctrine is capable of being enforced in a court of law. But we have applied these principles in Article 14. But equal pay must be for equal work of equal value. The principle of equal pay for equal work has no mechanical application. Straight away, you cannot apply it. But in our case, it is a mechanical application. Has no mechanical application in every case. Article 14 permits reasonable classification based on qualities or characteristics of person recruited and grouped together, and as against those who were left out. Of course, the qualities or characteristics must have a reasonable relation to the object sought to be achieved. In service matters, merit or experience can be a proper basis for classification for the purposes of pay in order to promote efficiency in administration. A higher pay scale to avoid stagnation or resultant frustration for lack of promotional avenues is also an acceptable reason for pay differentiation. The very fact that the person has not gone through the process of recruitment may itself, in certain cases, may make a difference. Mode of recruitment is also to be considered. If the educational qualifications are different, then also the doctrine may have no application. Even though the person may do the same work, their quality of work may differ, where the person are selected by a selection committee on the basis of merit with due regard to seniority, higher pay scale granted to such persons who are evaluated by the competent authority cannot be challenged. A classification based on a classification based on difference in educational qualification justifies a difference in a pay scale. Mere nomenclature designating a person as, say, a carpenter or a craftsman is not enough to come to the conclusion that he is doing the work of which is produced may be different, and even the nature of work assigned may differ. This line is very much important. It is not just a comparison of physical activity. The Lordship may kindly bear in mind. It is not a comparison of physical activity. But so far our case is concerned, Rule 25(2)(5)(a), specifically it is a comparison of physical activity, equal work. I will get an actual place while referring the Supreme Court cases. It's a physical activity. The application of principles of equal pay for equal work requires consideration of various dimensions of a given job. The accuracy, let us skip these lines, how they distinguish. The last one, remember, last paragraph. In all these cases, we find that High Court has blindly proceeded on the basis that the doctrine of equal pay for equal work applies without examining the relevant factors. These factors are to be considered. So far, the comparison between the casual workers or daily wages workers with the other workers.
Perhaps it is not for the High Court to examine.
Yes, this is for the High
has to
Court.
examine whether that Deputy Labour Commissioner had examined it or not.
I will come this is. No, I want to distinguish the case. So far, these cases are concerned, which my learned senior has referred. A large number of cases are referred. All those cases are not at all applicable in our case because of the fact we have a specific law. This aspect of the case was classically dealt by the Madras High Court. I will refer that case. What is my endeavor before your lordship would be, now, when this problem was there, now,
Is there any specific decision on Rule 25(2)(5)(a)?
yes,
Any referred decision here?
Yes.
In a compilation?
yes, in my compulsion also. there.
How to proceed? The Deputy Labour Commissioner.
No, all these provisions were discussed. There is Vale Workers Union, 1985 1 SCC, page 630. All the scheme of the act and the rules were examined.
Let us
And
see.
after examining all this specifically, Supreme Court was of the view that there is no, what the term they have employed, indefious distinction.
compilation.
Our comparison to the
File when it was, no?
After examining all these provisions, the Supreme Court was of the view, thus we see that no indefious distinction can be made.
Let us see that judgment directly.
Yes, let us go slowly.
If it is specific to Rule 25,
Oh, yes. Page amendment to question. Page 19. page, our page 98, my lord.
Hmm.
98. 98 to 105. Para 5 and para 6. May let us read slowly. All the long title of the act describes it an act to regulate the employment of contract labor in certain establishment and to provide for its abolition in certain circumstances and for matters for connected therewith. As the long title itself indicates, the Act does not provide for the total abolition of contract labor, but only for its abolition, in certain circumstances and for the regulations of the employment contract labor in certain establishment. Numbers defined sections have been discussed. Section 1(4), whereof the employer were employed in any day of the proceeding, 12 months contract labor for every contractor who employs or has employed on any day proceeding. 12 months, 20 or more workmen. That is where there is a workman of 20 workmen or more than 20 workmen are employed in an establishment, this act will be applicable. That is the sum and substance. The act does not apply the establishment in which work of an intermittent or casual nature alone is performed. Section 2A defines an establishment as meaning, number 1, any office or department of the government or local authority. It is applicable to all establishment. Or any place where any industry, trade, business, manufacture, or occupation is carried on. Section 2G defines the principal employer as meaning in relation to any office or department of government or a local authority that the office department, that office or department or such other officer as the government or the local authority, as the case may be, may specify in this behalf. 2, a factory, the owner or occupier of the factory and where person has been named as the manager of the factory under the Factories Act 1948. The person so named. In a mine, the owner or agent of the mine where a person has been named or manager, that is who is the employer, principal employer. Let us keep it up. Next, come. The definition of establishment and principal employer clearly do not exclude, but on the other hand, expressly include the government or any of the department of the Act applies them to. The Act is not confined to the private employers only. Section 2C defines a contractor in relation to an establishment as a meaning a person who undertakes to produce a given result for establishment other than mere supply of goods or articles, manufactures, or such establishment, though through contract labors or who supplies contract labor in any work of the establishment includes subcontractors. Who is a contractor? Contractor may undertake to perform certain job on behalf of the principal, or he may only supply some contract laborer to the principal employer to carry out their jobs. Two kinds of jobs. But a contractor who supply materials, they will not be covered under this contract labor exploit. Only the person concerned who undertakes to perform to give certain result of the principal employer, of the work of the principal employer, he will be amenable under this act. Or a person who supplies the laborers to the principal employer for their work, he will be amenable under this act. That is what they say under section 2C. Who undertakes to produce a given result for the establishment other than mere supply of goods or article of manufacture of such establishment through contract labor, or who supplies contract labor for any work of the establishment, includes a subcontractor. Section 3 and 4 provide for construction of the central and state advisory boards. Section 7 provides for the registration of the establishment. This is important. Every establishment which will provide, will take the help of the contract labor, their establishment must be registered. Section 7 provides that the registration of the establishment. Section 8 provides the revocation of the registration. Section 9 provides for equal effect of non-registration. For the effect of non-registration, Section 10, which is important, provides that and enable the prohibition of employment of contract labor in any process or operation and other work employment in establishment. They have quoted Section 10. So far our case is concerned, Section 10 is not very important. Section 10 empowers the appropriate government to abolish engagement of contract labor. How they will abolish, that procedure has been prescribed, and while abolishing these things, they are to take the advice of the advisory boards. That is what contained in the Section 10. So far our case is concerned, it is not very relevant. Our case, Section 12 is relevant. So let me skip it off, because it's a long section. Now, Section 12, we have some relevance so far our case is concerned. Section 12 provides for the licensing of contractors. It is very much important. Section 13, 14, and 15 provides for the grant of licenses, revocation, suspension, amendment of licenses, and appeal. Section 16 to 21 make detailed provisions for welfare and health of contract labor. Section 20 in particular provides that if any amenity required to be provided for the benefit of the contract labor employed in an establishment in establishment is not provided by the contractor within the prescribed time, such amenity shall be provided by the principal employer. Section 21 makes the contractor responsible for payment of wages to each worker employed by him as a contract labor, but further prescribes that the principal employer shall nominate a representative duly authorized by him to be present at the time of disbursement of wages by the contractor. Section 22 to 27 provides for penalties and procedures. Section 28 provides for appointment of inspecting staff. Section 30 makes, it is very much important, Section 30. Section 30 makes the provisions of this act effective, notwithstanding anything inconsistent therewith contained in any other law in terms of any agreement or contract of service or any standing orders applicable to the establishment. This is an important section. I will place it later on that. If, however, says to the contract labor any favorable benefits. Now, subsection 2, 30, that is subsection 31 and subsection 32 two states. If, however, saves the contract labor, say, contract labor any favorable benefit that the contract labor may be entitled to under the agreement, contract of service or standing orders. Section 35 invests the appropriate government with the power to make rules for carrying out the purpose of this rule. Now, in exercise of this rule, my lord, this rule 25 have been framed. Rules made by the central government are required to be laid before the House of Parliament for a total period of 30 days. In exercise of the power conferred under Section 35 of the Contract Labor Regulation Abolition Act 1970, the central government has made Contract Labor Regulation Abolition Central Rules 1971. Chapter 2 of the rules relating to the matters pertaining to the Central Advisory Contract Labor Board, while Chapter 3 rules, we are concerned with Chapter 3 rules deal with the registration of the establishment and the licensing of the contractors. Here, the most important thing is this Rule 25. Rule 25 prescribes. Rule 25 prescribes the forms, terms, and conditions of the license. Rule 25(2)(4) prescribes that it shall be the condition of every license that the rates of wages shall not be less than the prescribed under the Minimum Wages Act 1948 for the employment where the applicable and where the rates have been fixed by the agreement, settlement, where the rates have been fixed by the agreement, settlement not less than the rates so fixed. Rule 25(5)(a) prescribes that it shall be the condition of every license that in case where the workman employed by the contractor perform the same or similar kind, that is very much important, where the workman employed by the contractor performs the same or similar kind of work as the workman directly employed by the principal employer, the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workman in the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or the similar kind of work, provided that in case of any disagreement with regard to the type of work, the same shall be decided by the Chief Labor Commissioner Central. Now it is Deputy Labor Commissioner. Chief Labor Commissioner Central, whose decision shall be final. Similarly, Rule 25(5)(b) provides that in other cases, the wage rates, holidays, hours of work, conditions of service.
These are all rules.
Now, last conclusion of the clause is paragraph 6. Thus we see, what is the conclusion of the Supreme Court? Thus we see that no invidious distinction can be made against a contract labor. This is very much important. Contract labor is entitled to the same wages, holidays, hours of work, and conditions of service as are applicable to the workman directly employed by the principal employer of the establishment on the same and similar kind of work. Now, Lord, this judgment was referred to another Madras High Court.
Before that, on a plain reading of Rule 25(2)(a)(1), this rule, contract labor rules, in cases where the workman employed by the contractor performs the same or similar kind of work, right? Now, whether this has to be read along with section 18(3)(d)
I will
of the industrial, my question is.
Yes, 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 yes.
You have to be very specific.
Hmm.
Section
18(3)
18(3)(d)
of the Industrial Dispute
Industrial
Act.
Dispute Act says, if it is a after conciliation or whatever, a settlement is arrived at by,
Conciliatory settlement.
yes, then it is binding,
Binding.
right? That is binding.
Yes.
In the presence of binding to all,
Binding to all.
Right.
Right.
right? In presence of such a settlement, because this rule is silent,
Yes.
right?
No, not silent. I will explain
No,
it.
just a minute. Not specifically expressly, it is not expressed in Rule 25. Now, there is a binding settlement
Yes.
under Section 18, right? Then, whether in presence of such a binding settlement, this Deputy Labor Commissioner can assume jurisdiction to again go for
That is your lordship's second question.
similar
Yes.
pay beyond the binding settlement?
Yes. That is second question, your lordships. I will. Okay.
Because everything hinges between interrelation to my understanding,
No,
interrelationship, interplay of the provisions of Section 18 and Rule 25. Firstly, that is the first question, whether in presence of such binding settlement, this Deputy Labor Commissioner, just because of an application filed by one trade union, can go for.
I will answer this question.
That is the first question.
No, probably
That is the
question was-
foundational question.
No,
And
first
it
question
goes
was
to the
that.
root of the matter.
No, if your lordship.
If any authority has answered this question.
Yes, I will. Well,
No,
let me.
Specifically.
Let me conclude this.
Because Rule 25, it says simply about something.
Well, let me
There is
conclude.
no non-obstante clause.
Well, let me conclude this thing. Then I will answer this question. Because three questions that I have to answer. First question is this. Second question is binding nature of the settlement. And third question is the power of the deputy commissioner, deputy labor commissioner to add 5,000, 3,000.
First question is to be rephrased in the sense that whether, that will be second question, whether the deputy labor commissioner.
So let us assume that is the first question.
Okay.
Let us assume that is the first question. And then
Second question.
this is second question. So let me answering the second question. I will, after concluding this, I will later. Firstly, on that day, you also ask first question, this one. So let me finish this question. Then I will answer this question. And third question also I will answer. Thus we say there is that no individual distinction can be made against the contract laborer. Contract laborer is entitled to have the same wages, holidays, hours of work, and conditions of service are applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. Well, I am answering the second question first. What? They are entitled to recover their wages and their conditions of service in the same manner as workers employed by the principal employer under the appropriate industrial and labor laws. If there is any dispute with regard to the types of work, the dispute has to be decided. The dispute has to be decided by the Chief Labor Commissioner, nowadays Deputy Labor Commissioner. It is clear that Parliament has not abolished the contract labor. That is not very much important for us. Now, this is the best question. Paragraph 6. There is no individual difference. No, sorry, Miller, I'm going to second question first. So let me finish it. Then I will come to this. because I have not
Yes,
finished this
yes, yes, yes.
Jagjet Singh case also I have not finished. My lord.
Yes, yes.
Hmm. So as you also asked me
Sure.
this question. Now, yes, Lordship. So, one second question I'm telling. Say, equal pay for equal wages. There should be some distinguishable features. That is source of recruitment, qualification, responsibility, etc. Whether this principle will be applicable in the case of the contract labor and the principal employers. What? Second question I'm answering. Now, my lord, some light can be given by a judgment of Madras High Court.
Okay.
That is, your lordship will find to Airport Authority could say.
Page
Oh, well,
24.
page 24. So, I'm position. But some paragraphs I would like to read out. Paragraph 8, 9. Here, my lord, the case is to some extent similar to our case, my lord, because that the petitioner has relied upon those decisions, my lord. There is a spiral binding. This is the spiral binding. All these cases have been discussed here. Straightway, your lordship come. One paragraph, paragraph 9, 8 and 9. Page 30. Our internal page is 30. Paragraph 8. गंडगोल है ऐसे तो कोई नहीं बोलेगा गप्पी No, your lordship, come to paragraph 13. That is the case which I have referred now from the Jagjet Singh's case. The court has also held in the state of Haryana versus Charanjit Singh, 2006, 9 SCC, page 321. That is referred at Jagjet Singh's case at paragraph 37.2. That the doctrine of equal pay for equal work can be invoked only when the employees are similarly situated, and that similarity of the designation or nature or the quantum of work is not determinative of equality in the matters of pay scales, and that the court has to consider the several factors only. If there was a wholesale identity between the holders of the two posts, equality clause can be invoked, not otherwise. Now, my lord, this court has also held in the state of Haryana versus Charanjit Singh, 2006, 9 SSC, page 321, that normally the applicability of the principle of equal pay for equal work must be left to be evaluated and determined by the expert body, and there are not matters where the writ court can lightly interfere. This court has further held that this decision is that is only when High Court is convinced on the basis of the material placed before it that was equal work and equal quality, and that all the other relevant factors were fulfilled. It may direct payment of equal pay from equal date of filing of the respective petition. Now next. In the pronouncement made by the official liquidator versus Dayanand such and such paragraph 95, it has been observed by the court has follows below. All this case below, that is the ratio of Randhir Singh versus Union of India was reiterated and applied in several cases. Dhirendra Chamli versus State of UP, Surinder Singh versus such and such, daily rated casual labor worker. They have referred all those cases here, Lord. Daily rated casual labor union, first instance, therefore, Lord, Employees Association, State of Karnataka, Jaipal, Haryana, all those cases, Lord, they have referred. And here also, Lord, the petitioners have referred all those cases in this spiral biting. The court consciously and separately deviated from the ruling of Randhir Singh Union, etc., and held similarity in designation quantum of work are not determining of the equality of the matter of pay scales, and that before the entertaining and accepting the claim passed by the principles of equal pay for equal work, court must consider the factors like the source and mode of recruitment, appointment, qualification, nature of work, the value of the judgment, responsibility, reliability, experience, confidence factors, need, etc. Now, Lord, they have relied upon this judgment, Lord. The said judgment of the Honorable Apex Court do not deal with the similar situation. The judgment, therefore, not the similar situation. The said judgment of the Honorable Apex Court do not deal with the similar situation on hand, in which the employees concerned have approached the authorities under the Contract Labor Regulation and Abolition Central Rules 1971. The issue of those cases was fixation of pay between the casual and the permanent employees. The issue has been raised directly either before the Central Administrative Tribunal or before the High Court, which ultimately ended before this Honorable Supreme Court. Therefore, this court is of the view that the said judgment relied upon by the learned counsel for the petitioner do not have any application to the case on hand. Now, next paragraph. In order to appreciate the issue before this court, it is relevant to extract the Rule 25(5)(a) of the Contract Labor Regulation and Abolition Central Rules 1971. The same is extracted hereunder. Let me skip it up. The provision contained under Rule 25(5) of the Contract Labor Regulation and Abolition Central Rules 1971 makes it very clear that in a case where the workman concerned is employed by the contractor, performs the same or similar kind of work as the workman directly employed by the principal employer, then the benefits to such person shall be the same. as applicable to the workmen directly employed by the principal employer. Therefore, the said rule mandates that the benefits should be equal to both workmen engaged by a contractor as against the workmen engaged by the principal employer. Hence, considering the said provision coupled with the factual findings given by the first respondent, this court is of the view that the contention of the learned counsel for the petitioner cannot be accepted. In well, just now I have referred. In Well Workers Association, Haddad, and others, Union of India, and others, 1985 1 SCC, page 6 CG, considering the very same rules, it has been held by the Honorable Court. They have quoted the judgment which I read, my lord, all these things, section 3C, etc., etc. Up to this much. Thus, we say no invidious distinction can be made. Entire things, paragraph 5 and 6. Against the contract labor is entitled to the same wages, holidays, hours of work, and the conditions of work of service as applicable to the workmen directly employed by the principal employer of the establishment on the same and similar kind of work. They are entitled to recover their wages, their condition of service, and the same manner as the workers employed by the principal employer under the appropriate industrial labor law. If there is any dispute with regard to the types of work, the dispute has to be decided by the Chief Labor Commissioner Central. It is clear that the Parliament has not abolished the contract labor. No, they have simply quoted all these things. Paragraph 6, as I have quoted. Yes. And decide whether the employer the contract labor, any process, operation, and other work, consignment, etc., etc. Just simply they have quoted all these things. We have no option but to dismiss both the parties, but the paragraph 2, the said decisions of the Honorable Apex Court has been quoted with the approval in a subsequent pronouncement in such and such case of the Supreme Court, AIR 2009-2373, when it has been held as follows. A bare reading of the provision makes the provision clear that in cases where the workman employed by the contractor performs the same or similar kind of work as employed directly by the principal employer of the establishment, the wage, the rates, holidays, hours of work, and the other condition of services of the workman, of the contractor, shall be the same as are applicable to the principal work. In case of the disagreement, they agree by the Commission. Hence, considering the all facts and compromisation position of law, after considering the object and behind the contract labor, this court is of the view that the impugned is perfectly all right. Now, my lord, so far Jagdish Singh case is concerned, unless your lordship specifically asked me this question. When the Supreme Court has decided, if I remember correctly, your lordship asked me, when the Supreme Court has decided that the casual labor is only entitled to the minimum scale of pay, then how this person, who is a deputy labor commissioner, can give this order? This was the question specifically. And second question was that the present case is covered by the conciliatory settlement.
Interplay between
section
18.
Section 18 of the Industrial Dispute Act. That was the second question was put by your lordship.
Because Rule 25 is silent about
Rule 25 is silent.
existence of any binding
Your lordship's query was that the Rule 25 is silent with regard to the conciliatory settlement or any settlement. It is stated only agreement and the condition of service. It is only stated this agreement, condition of service, and the standing order in force. But there is nothing mentioned in Rule 25 to the effect of conciliatory settlement.
All
Your-
these judgments,
Uh-huh.
both the judgments you have referred to, there is nothing, it is silent about the existence of any bipartite settlement.
No.
Nothing. It has simply said.
No, I am referring this question only because your lordship's anxiety was that even if we examine equal pay for equal wages, then also you are to give the minimum scale of pay.
Is there any decision discussing the interplay between Section 18 in Industrial Disputes Act vis-a-vis Rule 25 of the contract labor rules?
I have not checked up this decision, but I brought some decisions here also, Millard.
But any
My endeavor in this regard.
because that will solve the issue instead of hearing.
As because your lordship.
First, fundamental issue, that whether Deputy Labour Commissioner can assume jurisdiction to decide.
Despite having the conciliatory settlement.
Decide on similar pay, for similar work, despite having a bipartite settlement.
That is not only bipartite conciliatory settlement, which is binding to the parties and the
in existence.
Parties in existence and the person concerned who are not party, to them also it is applicable.
By operation of law, that is also binding on them.
I will answer.
Thereafter, he will cross that bar, whether he has the authority to ignore it and proceed further.
But now it is 15 almost.
I have to.
Only 2 minutes or 3 minutes, your lordship. I will like to detain your lordship without going to the reading of judgment, because the reading of judgment takes much time.
So,
for the
Kolida, do you have anything on this point? Interplay between Section 18 of the Industrial Dispute Act and Contract Labor
I will place this thing.
Act.
So far,
More particularly, Rule 25.
so far, just I will take 2 minutes.
That will clear the air cloud.
Now, I am just finishing this case by 2017 148. I will not refer any paragraph because there's paucity of time. Now, Lord, where this type of situation arose because of not having any law, what is to be done? Now,
that is why I am asking.
Yes,
not
yes.
having law, then I'll
yes.
make
That is
my
what is to be-
independent application of mine.
Yes. That is your
Without-
very
without-
very pertinent question. Now, this question was answered by the Umadevi's case.
Without having any roadblock.
Yeah, without having a
I'll go straight.
go straight. Umadevi's
Otherwise, if there are some decisions,
Well,
I have
we
to
are-
go here and there to discuss, either to agree or to
Disagree.
disagree.
But here we have law. But your query, lordship's query was
No
that.
direct point, perhaps.
Huh?
Not directly.
Yes, directly.
Directly. Show us
Wait.
that interplay.
Yes, I have read it. Yes.
No.
85-1 Supreme Court.
There is nothing. Absolutely nothing.
Absolutely
That
everything. Lord.
Deputy Labour Commissioner has the competence to decide on the issue of similar pay, similar work. There
My lordship,
is
please write.
silence.
Please write paragraph 6.
I have
Again,
read it twice.
I am reading it again. This is only one line, it will suffice this.
He has the jurisdiction,
No.
authority.
Not your lordship is completely wrong direction, Lord. Paragraph
Maybe I am
6.
wrong.
Completely wrong direction, Lord. Paragraph 6. Thus we see no individual.
Once again. Veil worker.
Yes. Otherwise, my entire report will be behind me, Lord.
Maybe my understanding
Yes.
is this.
Yes. What is my thinking, Lord? Thus we see
Paragraph
6 at page 104. What they want to say here?
Yes.
Let me. thus we see that no.
What is the meaning of in VD?
Yes, it's a dictionary meaning. I have checked it.
Ah.
I will give it to you later.
No, I cannot.
Individual. This is a meaning, Lord, and this has clarified another case, Lord. This is referred in this Madras High Court, and in what is the meaning of invidious? I will bring this dictionary meaning.
There is absolutely no doubt to the proposition that contract labor, if they do similar work, then they must get similar pay as like regular workers.
But
Right,
and you
that is
cannot-
settled.
and you cannot distinguish that they are not source of recruitment.
That is not a
etc.
question.
Mm.
I am 100% agreeable with you
But
with
then,
that proposition.
then my purpose.
But question is
Now second question.
interplay.
No, if your lordship is 100% with me, then my problem solved. Now,
That proposition.
rule 18, section 18.
No, that is rule 25 to
Section 18.
5, Roman 5, 1,
A.
simpliciter. Am I been, whether I am able to convey the meaning?
Yes, yes.
So, standing alone,
Oh.
25 to 5, 1.
Hmm.
I am absolutely with you.
Yes, then all that.
But if section 18 of the Industrial Dispute Act
Second
comes
question.
into
Yes, yes.
the scenario,
Yes.
whether
This rule 25.
same will be applicable.
Yes. Whether
Whether
otherwise,
then deputy,
whether rule 25 2A will be diluted
25 to,
by the conciliatory settlement.
yes, by 18
Ah.
to
Yes.
D.
Yes. Yes. So whether rule framed under
Any discussion
Yes,
anywhere in any authority, that is what I am asking.
yes, I will place it. So, your lordship, second question, let me get myself clarified. What is your lordship's query is that when there is a conciliatory settlement, whether that settlement will override Rule 25A
No, my,
or or Rule 25A will have no application if there is a conciliatory settlement.
basically interplay of section 18 2D and rule
whether the section-
25,
whether rule section
whether one provision will have an effect on the other provision.
Yes, yes.
Basically, that is
or
that
simple
is the
question-
broad question.
or your lordship, simple question is whether section 18 of the Industrial Dispute Act will prevail upon Rule 25.
Basically, what is the effect of one provision
yes.
on the other?
Yes,
That
yes.
is a simple question
Yes,
first.
I will answer this question.
Then thereafter, we'll go into the nitty-gritties.
So far the minimum way,
That is,
I will just, tomorrow, your lordship,
tomorrow again, I will be rising at 3:15. There will be lots of
Otherwise-
motions.
first question I have answered, or your lordship take any time. Well, this is an interthing. It is a process of learning to myself.
No, I am learning it.
Moreover,
Suckling,
we have been blessed by the presence of very well-known lawyer.
It's
of
a very
India.
new thing to me. Learning.
Very well-known lawyer of India, having all India station, additional additional Solicitor General, Advocate General.
We are eternal students. This profession is
Yes,
there.
yes.
That is my understanding.
When I entered in this, he was my guru actually. I considered it.
No,
11th of August.
No, 11th I can.
even though there is one matter fixed already, I'll take up. 11 January.
No, this week, there
No
is
problem, no problem. You have to fix any date.
series of interviews.
No
We
problem.
have. Your lordship is speaking at 2.
On that day, Miller, I shall take 2 or 3 minutes time for Jagdish Singh's case.
Yes, yes.
Yes, yes, take as long as.
Sure. Invidious means unfair or unpleasant.
There's other meanings. My friend.
Yes,
brought it.
Mr.
He brought it. I will bring all those.
I go to repeat very more side. 11, 8, 2 p.m.
Instead of 11, could it be on Thursday?
All right.
11
13th.
is 13 আছে নেকি চাই লওঁ পাৰিব ইনকাম টেক্সৰ চিৰিজটো নাইতো 13
So I will bring the dictionary meaning of this word.
no already I have
13, 2 o'clock or?
2 o'clock that day we had it at some length, right? Okay, 11. নাম কেইটা লিখি দিব 11 11 18 আছে নেকি 18 পাৰিব 11
Item number 8, eviction matter.
This is the matter.
day after tomorrow
Very good.
day after tomorrow MSA KB পাঠক item number কিমান
8.
8 Thursday